Go ahead and call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled Heather Nielsen and Nicholas Nielsen versus Knight Industries Incorporated, case number 23 AP 202. Representing the appellants, Heather and Nicholas Nielsen, is attorney Chandler W. Matson. Representing the appellee, Knight Industries Incorporated, is attorney John L. Franco.
Thanks very much, and good morning, counsel. We'll hear from counsel for the appellant first, of course. Please introduce yourself, identify your client, and then proceed.
Good morning, Your Honors, and may it please the court. This is attorney Chandler Matson on behalf of Heather Nielsen and Nicholas Nielsen. Your Honors, this is a fairly heavily briefed case considering the simplicity of the domestication action, which are usually pretty straightforward. But this case has not been so straightforward for reasons that were unpredictable. Some very obvious facts emerged, which was a professional process server went to the only office of the proper defendant, found the person who dealt with the contract in New York that my clients entered into, the only Knight person who dealt with anybody in New York, according to the record, and entered into the contract with my clients. Professional process server signs an affidavit that service was properly made. Lawyer for, and this is me, by the way, appellants receives an email confirming the receipt of the complaint. The action proceeds. Defendants are given notice of the default judgment. They're served with all papers via FedEx and fully confirmed further with calls from the defendant saying, you've moved for default judgment against us. The defendant has full knowledge of everything that's going on, and the plaintiff is fully relying on common sense, reason, and knowledge of the facts that are happening, that this person has full knowledge of what's happening and is just
Mr.
simply
Matson, does full knowledge equate with appropriate due process concerns?
Well, full knowledge is the umbrella term. Look at the specifics, though, Your Honor, of this case, right? Again, this is an unregistered corporation doing business in New York, which is required to have an agent, but does not file and have an agent. So it becomes a de facto agent question. Steve Bankert is the only person from Knight who is doing business in New York. He is the only agent in New York. And that is so on top of full knowledge, which clearly the officers and the employees of Knight have full knowledge of the complaint. But additionally, they only have one agent in New York, and that's Bankert, and that's the person who was served. Now, the story, this case has become like whack-a-mole. Every time I file a very simple application or I make a simple request and I get the answers back and then use the answers, which are demonstrative of my position being that the proper service was made, they change their story. The depositions that I took that confirmed the facts that I needed for summary judgment came back with an errata sheet directly contradicting their own testimony. Judge, I make a point, I make a position, it's obvious what happened, and then the defendant simply changes their story and files something in an affidavit form or whatever that completely contradicts the record. And that ultimately answers the question before Your Honors, which is whether the movement was given all, the movement and cross movement were given all fair and reasonable inferences from the facts presented. And I was not. The appellants were actually on the short end of that stick, and the inferences were made against the appellant.
But Mr. Matson, what I was looking at was the Vermont trial court's analysis of the New York court service laws on what's proper service and what's not proper service, and making a determination that the person you're saying is the agent was not the agent sufficient to receive service of a complaint.
So understood, Judge, and we are here de novo, but I'll just say that the record is that, once again, Bankert is the only agent in New York. There is no other agent in New York.
Was he served in New York?
No, they were served at their offices in Vermont. So they didn't have an office, Judge, in New York. They only had an office in Vermont, which is why we served them in Vermont. And again, the process server, a professional process server, the sheriff signs an affidavit saying process was made. The questions, it's not, again, the incredible story from the defendants is that this process server, a professional sheriff process server, walked in and simply dropped an envelope on Bankert's lap. Bankert didn't know what it was, and so he just disregarded it. And that is their story. And the fair inferences I presented, which discount and disclaim that story, were completely disregarded by the trial court. And that's why we're here. And I would like to reserve some time, but if your honors have questions, I would be happy to answer them.
Well, you have a minute left, it looks like. So unless I don't see any hands, so let's go to counsel for the appellee. Please identify yourself and your client and then proceed.
Your Honors, good morning. I'm John Franco. I'm the attorney for Knight Industries, who's the defendant and the appellee in this case. Basically, we asked the court to affirm the trial court's analysis and dismissal of the domestication petition for its failure to follow New York State's jurisdictional requirements. One of the earlier questions was about due process. This isn't about an international due process kind of claim that we were taught about when we took civil procedure law many decades ago. This is about the New York civil practice and law rules, which are rules adopted by the New York State legislature. And they have specific requirements for the service of a foreign corporation. Frankly, they are old school rules about formalities of service, different than the rules that we have in Vermont, which are more notice pleading kind of, or actual notice kind of rules. But that is the jurisdiction, that's the regime in New York. The trial court did an extensive analysis of why that was not complied with. There's ample opportunity for the Nielsens to serve properly. They could have served the New York Secretary of State. They could have serviced any of the Ritters, George Ritter Sr. or George Ritter Jr., Eric Ritter, or Annie Ritter, and none of those people were served. And as the trial court correctly pointed out, that under New York law, that the papers finally end up in the hands of the people that run the company is not sufficient. The evidence of improper services provided by the Nielsens themselves in the two service affidavits that they supplied to the court in New York and to the state Supreme Court for Nassau County. And there's absolutely no contradiction.
Franco, I don't mean to be argumentative. I'm not going to argue, but just the fact that the whole purpose of this is to allow a party to receive notice of a lawsuit in a foreign jurisdiction. And I mean, I understand the New York law and the restrictions that are there, but in reality, your client did receive notice of the pending lawsuit in New York State. Would that suffice?
No, not under New York law, it doesn't. That's an actual notice requirement. That's Vermont's standard. It's not New York's standard. It hasn't been. And we've cited cases where courts in New York have tried to go to the actual notice standard, and it's been rejected by the courts and say, look, at the legislature of New York, in adopting the New York civil practice and law rules, has established these requirements, and they've been long-standing, and they haven't changed. The question is whether or not service was proper under New York law. It was not. And there's an alternative grounds that we have briefed for upholding the decision of the trial court to dismiss the petition, which was the failure of the Nielsens to amend their complaint to name Knight Industries as opposed to Knight Kitchens, which is a requirement also of New York law. Now, the trial judge, we think, made an error where she said that this was a procedural requirement, not a jurisdictional requirement. Our brief has pointed out that this is a jurisdictional requirement under New York law. Now, in the reply brief, the Nielsens have said, well, we can't raise that because we didn't bring a cross appeal. Well, this court's decision in Starusky versus Continental Telephone, 154 Vermont 568 footnote 3, makes it clear that we had no reason, we had no ability to file a cross appeal because we are content with the final order of the case. The final order of the case is the dismissal of the petition for domestication. And since there was no basis to file a cross appeal, we are entitled to raise this question about their compliance with the amendment requirements of New York law. And those alternative grounds were briefed and they were preserved below. So there are really two grounds here for affirming the decision of the trial court. One, the decision that it made, which we think is absolutely correct in its analysis, but alternatively, for the failure of the Nielsens to amend. I mean, what we were served with was a lawsuit against Night Kitchens Incorporated rather than Night Industries. That's a misnomer filing, and under New York law, they had to make an amendment. Different than the Vermont rule, but that's the New York law.
And Mr. Franco, the failure to amend, is that considered one of the irregularities under CP LR 2001? So that's why there's no jurisdiction?
I think it's a 305C. I think the case law is 305C.
All right.
We cited the I think it's the Maldonado case and a series of other lower court decisions that say, one of them says quite specifically that you can't come in after the fact if you get the default order and then say, oh, we need to amend who it is addressed to. And that was specifically rejected, and we briefed that.
Right. Okay. Thank you.
All right.
I'm finished if there's no other
Yep.
questions.
Thank you very much. Your time has expired. How much time does the appellant have, please?
Appellant has 10 seconds remaining.
All right, counsel.
Thank you, Your Honor. So just reading from Fashion Page v. Zurich Insurance, which is cited in our brief, quote, if service is made in a manner which objectively viewed is calculated to give the corporation fair notice, the service should be sustained. I understand why the defendants and appellees are making as many technocratic arguments as possible, because the fact is they had notice. They defaulted on a judgment with full notice of it. So they're looking to parse the words as tightly as possible to avoid that.
Okay.
The fact is,
What's technocratic? What's that mean?
technical arguments.
Technocratic?
Right. Taking the most technical definition of the words as possible, narrowly construing them so as to avoid the common sense analysis, which is, again, back to Fashion Page, that the corporation was given fair notice and they were served by their agents.
All right.